All right, I think if we want to get out of here by 10:15, we probably need to go ahead and get started, even though I bet half of the conference is still eating breakfast. So just a reminder to mute your cell phones if you haven't done that already this morning. My name is Laura Klossner. I'm with Guardian Ad Litem in Seminole County as a program attorney. Go Circuit 18. For me, law is my third career. I started off as a high school social studies teacher, and one of the things I taught was psychology. So I started to get interested in psychology and mental health. Then I was a mortgage broker during the height of the market, and when that tanked, I said, oh, the heck with it, I'll just go to law school. So I went to law school on a whim, and thought I'd be a property attorney or something, some simple little desk job and make tons of money. And instead, I became a juvenile public defender. So I worked for the Ninth Circuit Public Defender here in Orlando and Osceola counties for almost 8 years. The majority of that, Ronnie worked with me too, the majority of that was in the juvenile division. But for just over a year of that, I served as our office's mental health attorney. So I had all of the adult misdemeanor cases that were incompetent. I covered and handled all of those. I handled all of our adult felony clients who had been declared incompetent or insane. I went to all 5 of the state hospitals visiting our clients. I did medication hearings and things like that. So that was how I got into mental health law. It was just purely by chance of the jobs. I was not a psychology major in college, so I do not deem myself an expert on mental health and psychology. I can help teach you how, as a lawyer, how I learned to advocate for mental health clients. So that's the extent. There are probably people in this room who have far more expertise in mental health than I do. So please feel free to share your knowledge. I will not be offended. Feel free to ask questions during my presentation. Teaching high school, I'm used to being interrupted, so just raise your hand and I'll call you out. But I did see, working both juvenile and working mental health, I was absolutely shocked by how many kids in our juvenile justice system, both dependency and delinquency, and then direct files particularly, how many kids are affected by mental health. I mean, the estimate is that as many as 20%, up to 50%, some studies show, of kids in the juvenile justice system have mental health issues. When I was supervising our juvenile division and the public defenders, I would tell my attorneys, if 20% of your caseload is not declared incompetent, you're missing something. Because for kids, incompetency can be age and immaturity. It can be just a lack of knowledge about how court works. Well, how many 12, 14-year-olds know how court works? So that's something just to keep in mind, that to find a child has mental health should not be surprising. So one of the interesting things that I found in researching for this was this handout from the National Institutes of Mental Health from 2016. It's in the application documents, and if for some reason you can't get to those documents on the app, if you have trouble uploading them or anything, just email me. I'm happy to send you everything by PDF via email. But this, I thought, had some interesting statistics in it, just helping show how prevalent mental health issues are among children. The fact that suicide might be about the 9th or 10th leading cause of death among the general population, but among children, it's usually the 2nd or 3rd leading cause of death. So, when you look at all of the trauma and all of the issues and the things that our kids are going through, this is a major concern. Not treating these kids correctly can literally lead to deadly consequences. And the numbers do vary. That's why I put in at the corner the 2017 Health and Human Services, their report. Their numbers are slightly different. So, in candor to the court, if you're presenting some of these things or having experts testify, give them everything you can find so they can point out that there are differences. But like I said, the prevalence is just extremely high, that approximately 1 in 5 youth between 13 and 18 will have a severe mental disorder at some point during their life. Even when you go down to children as young as 8, the number is still at 13%. Like this statistic that said nearly 70% of youth in the juvenile justice system have had at least one mental health condition, and 20% of them live with a serious mental illness. The fact that so few of them, that only about half of them receive any kind of treatment for that, and that half of all of these chronic mental illnesses, so something that's going to be long-term in their life, will begin by the age of 14. I mean, I've had delinquency clients who were 7. They were charged with battery on a teacher because when they were put in the padded room, they kicked back. So that was battery on a teacher, felony in Florida. And 7 years old, and she was paranoid schizophrenic. And Jeff Danziger evaluated her, and he said, I didn't believe it. He said, I do think this is perhaps the youngest person I've ever seen that I would agree is truly paranoid schizophrenic at the age of 7. So it can happen.
Can I ask a question?
Yes.
When you use the term mental health services, are you including or excluding the prescription of psychiatry?
Yeah, I'm betting it's include. The question was, would mental health services include psychotropic prescription drugs? And I'm betting with these statistics it's including it. Because that would also imply that they've seen a psychiatrist to get prescribed that, and seeing a psychiatrist is considered treatment. So my guess would be that yes, it includes that. Right, yeah,
Kids, even if they don't have a diagnosis in the medical journal, they're all having mental issues by the time they're in the
well, to me, trauma is a mental health issue. It should be a mental health issue.
100%.
Right. Right, I would agree with that. I mean, is there anyone in this room who would actually want to argue that these numbers might actually be too high? I'm not seeing anyone willing to take that on. The consequences of it, it's been estimated that we spend nearly that we lose nearly $200 billion a year in lost earnings due to mental health issues, and that's of youth and adults. So granted, maybe children aren't contributing a lot to that, but how this isn't a national crisis in this country, I don't know. Not surprisingly, when you look at what type of mental health issues are the leading cause in children, it's mood disorders. Major depression, dysthymic, bipolar, that sort of thing are the leading disorders, mental health issues in children and youth. Third most common cause of hospitalization. I mean, think about how many kids you've had that have been Baker acted. That's a hospitalization, technically. Look at the things about education. That 37% of students between 14 and 21 who have a mental health condition and who have special education services drop out. Highest dropout rate of any disability is due to a mental health disability. And like I said, that suicide is usually somewhere 9 or 10 among all causes of death in the US, but yet it's usually second or third for young people. How few youth receive treatment? Only about 40 to 50% of kids who have even something, and not to downplay it, but if you say something as simple as depression, we're not talking paranoid schizophrenia, we're not talking violent, issues. We're talking depression. I mean, think about how many depression drugs are there on the market. So few of them can be used on children. But you've got nearly, or just over 3 million adolescents with it, and only about 40% of those even get treatment. This one really shocked me too. Please, encourage people, go into psychiatry, psychology, that sort of thing. 15 million children and adolescents need psychiatric help. So a doctor who can prescribe medication. but there's only about 8,300 psychiatrists in the US who can work with children and adolescents. That worked out, I'm horrible at math, so I put it on the calculator. That would mean if we spread that out among all the psychiatrists, they'd each need to have a caseload of about 1,800 kids. So we need a few more experts who can work with children and adolescents. And then, as we know, children who live in foster care have a substantially greater risk of experiencing a mental health, primarily because of the trauma, the stress, the abuse, the neglect, all of those issues that create mental health disorders. This link is a really good resource. It's actually specifically about how adults can support adolescents with mental health issues. So it's great for our volunteers, for us in the Guardian Ad Litem program, for people working in social services with kids. So it's a great resource to look at. And then a few other statistics. This mental health is an area, I know there's been talks this week about school to prison pipeline, and we get into racial and gender issues and things. White females are going to be the largest group with mental health issues. So it's kind of goes the opposite of what we normally see in the criminal justice system and school to prison pipeline. We're looking at children of color and minorities and typically males and things like that. But when you look at the numbers, and biracial, that's not really that surprising, because that comes with a lot of social issues and cultural issues and, extra things other than just normal adolescence to deal with. So looking at who, is typically in this population is important.
Can I ask a question?
Yes.
Is that self-report? Where did it,
This comes from SAMHSA. So I'm betting it's a combination.
Because it kind of makes sense that girls are more likely to admit, because it's a little bit more okay for girls to admit that she has
Right.
depression than it is for a boy.
Right.
So I wouldn't
We expect girls to have drama.
Right, yes, exactly. So I think that actually doesn't surprise me, because I think it's self-report that girls are probably more likely to admit, whereas the boys, who we're going to see more in the criminal justice system, but aren't going to
Yes.
necessarily admit they have problems, maybe that's what's skewing the statistics.
I would agree with that. And SAMHSA, if you haven't ever gone to their website, SAMHSA, and I can never remember what all that stands for. Great resource if you haven't ever gone to their website to find mental health facts, figures, stuff. Really good one. SAMHSA.
On that last slide at the very end, it had 2 or more. Is that
Race.
children?
Right.
That was the highest.
Right, so multiracial, right, that's the highest, and then white is the next. But, think about how many multiracial children, their parents mark them as white. So we're going to do a couple of things today. One, I just wanted to quickly go over the differences between the process for children getting mental health treatment via a dependency case through DCF, and children getting mental health treatment when they're in a delinquency case through DJJ. How many of you in here are lawyers? About half. How many of you are social workers, something along that line? Few. And volunteers for Guardian Ad Litem? Whew, thank you. Good, so like I said, I'm putting this forward as a legal advocate. But so please ask plenty of questions. But I just kind of wanted to make sure everyone kind of had the general overview. Has anyone worked in both delinquency and dependency? Good, yeah, about a third of the people in here, good. And if you've got something to add, if you say, that's not, we skip that. That's not the way it works in our circuit. Feel free to point that out, because this is kind of how it's supposed to be. This is for the DCF one. I worked with our people in our 18th circuit, our clinical utilization managers, and what they say, this is what we do. So if you spot something, you go, whoa, we don't do that. Feel free to point that out, because you might not be the only one. So in DCF, if you have a child who they believe has mental health issues, who's in a dependency case who's on a case plan, this is what should happen. They do clinical assessments. CBHA should start from shelter. Those take 6 to 8 weeks to do. The clinician has to go out to several places to see the child, get histories, write up that huge 15-page plus report. So you should see a CBHA come back on the child. They can do a mental health assessment, could also be called an intake assessment or a biopsychosocial assessment. They can do psychoeducational, and they'll often rely on the schools to do the psychoeducational. They can do behavioral assessments, substance abuse assessments, and then they can do psychological, neuropsychological, which is more specifically focusing on brain psychological, psychiatric and psychosexual. Those require the clinical utilization manager, or what I'll call the CU manager, to approve. So every agency, every county should have a CU manager. So get to know that person.
What is psychoeducation?
It's looking at how, more specifically, how school and your education is affected by the mental health issues. So like if you're only seeing the mental health issues, the symptoms, all of that pop up in school, go for a psychoeducational first, because typically the school will do it. Although if they already have an IEP or a 504 plan, there should be a psychoeducational already done. So go get that. See how old it is. They can redo them. Kids do change.
Generally, your school board's psychologist is doing that.
Yes,
We hope it's
correct. But it's worth having a baseline, even if you get it and you go, this doesn't reflect this kid at all. There you have a basis to ask for a different one, a new one by a different psychologist. Or we've had kids who, like, they have an IEP, but they, they've been shuttled around through 8 or 9 different elementary schools, and they've lost the psychoeducational. Well, let's redo it then. Let's see where they are now. Then they apply outpatient treatment interventions. They do individual therapy, family therapy, behavior analysis, substance abuse treatment again. This kind of scared me. They consider Baker Acts an outpatient treatment intervention. And non-traditional therapies like equine and yoga and things like that. So they get the assessments, they do outpatient. Then they look at levels of treatment. So now the clinical utilization manager is now the primary person on it. We typically do a multidisciplinary team staffing, that's an MDT. And most of these also require a full-on suitability assessment by the department. So they're looking at levels of care. So the kids should kind of go through these levels of care for their treatment. Have they been put in an enhanced foster care home? And that's very often a family who's been specific, who either has, as they would say in the movies, a specific set of skills, or a family who's been specially trained in different behavior therapies and treatments, and they're more familiar with mental health issues. They can go into therapeutic foster care, therapeutic group homes. Then we get into the residential treatment centers and the SIP beds and residential substance abuse and safe house and things like that. So dependency cases, they should be working through, trying all of those outpatient treatments and going through all that long before you get into residential treatment. Then we get into doing suitability assessments. So this is when we've tried everything else, child is not improving, we're getting to the point where even the guardian ad litem volunteers, the probably 4th or 5th case manager that this child's had, everyone is going, I think we need residential treatment for this child. And you can sit there as the person on the child's case and you can check off, okay, we have literally tried everything else. And yeah, maybe they didn't like their individual counselor. You know what? Try a different one. Have we literally tried everything else we can possibly try? Then if at that point everyone on that child's team is saying, I still think we need to look at residential treatment, then we look at doing a suitability assessment. The way it works in the 18th Circuit is the multidisciplinary team recommendation says that. So you can all go to that. You all sit through that and discuss, and the child has the right to be there. They're very often not there, but they have the right to be there if they'd like to be there. And then the clinical utilization manager, they use a system called Magellan as their software system. They upload a ton of stuff to Magellan. They make an appointment with an independent evaluator, so they get another evaluation of the child. They get that report back, and that report is specifically to recommend what level of care, as a clinician, what level of care they see the child needing. And then that goes into a motion by CLS to commit the child to residential treatment and have a suitability hearing. Keep in mind too, attorneys, that when you get to this point, if the judge agrees and orders the child to residential treatment, you should be having a suitability hearing, like a kind of like a check, a status hearing, every 10 days until that child's placed. Now, like in our courtroom, our dockets are every other week. So we push the envelope on that 10 days. So that should be happening. And the child has the right to be there. And that's in front of the judge. The judge is the only one who can actually order that child into residential treatment. The child can argue against it. I can assure you, and everyone I've ever done as the guardian ad litem attorney, I say best interest and expressed interest. I say, well, as a program that myself, the, child advocate manager, the volunteer, we went through all these staffings, we've confirmed all these other treatments. We are in agreement with the department that residential treatment is now needed for this child, but let me tell you what the child thinks. Yep.
When they're having the assessment done by the qualified evaluator, our volunteers are entitled to get input to that. So
Yes.
it's important for y'all to know if you didn't know that. You're supposed to
You can actually be present.
You can try to be present. We've
I had one of these cases, and believe me, they didn't follow any rules. I never had a suitability, never.
That's-
Said when that child went in 90 days, no more, she came out at 182 days. 180 double.
Well, that's the question. The judge can't really order the time limit, though, either.
Well, they couldn't find a suitable foster parent.
That's not surprising either. But yeah, you can definitely try, have someone from the program, from Guardian Ad Litem at that assessment. Some, especially the people who deal primarily with children and adolescents, their offices are very often set up for that. They might have like a one-way glass room or have it on closed circuit TV, or something to where you're not interrupting the process. Because believe me, even just sitting there behind the child can change their responses and their answers. So you want to be able to see it and to be there, but you may not want to actually put yourself in the room. So, yeah.
What do you do? I know who went to the shelter did this suitability assessment because he's big practice, and it didn't recommend any hits or STDC or any kind of higher level of care. But he has clear mental health issues. He's diagnosed with bipolar. His father in the history of schizophrenia in the family. His father something like that. So our CDC won't do a new suitability 6 months later, and we're pushing it, and they still won't because, or it's 4 months later. Sorry.
Right.
What do you do in that situation where there's a suitability that doesn't recommend anything, but you're seeing all these stuff?
Is he unstable? If he's still unstable, is he still getting Baker Act?
He's got big acting one suitability, which I push, like he has another Baker Act, let's do another suitability.
And at the very push for all of the other outpatient. Are they actually providing the child with all of those other services?
Some of them.
Right.
But we're also talking about like an account like he's now, where I'm on problems for hours, so they're like dealing with OCS kind of stuff, and I don't think that they're gonna try to do anything more, add any more services, but they're also not going to do suitability analysis stuff.
Well, if you can get the court to order them, they have to do them And there's plenty of case law out there, goes well back into the 90s, that says DCF cannot say money is the issue. Because that's, you know, you read between the lines of the CLS argument, and it's the, well, you know, we can't do that at this time, and you know. No. If the court orders it, and get the court to put a time limit on it. You need to have this evaluation done within 30 days, or you're going to come back and tell me why, and you follow it up with, can we set a status hearing in 30 days?
At the judicial review, at the judicial review, is able to get the magistrate to order an autism spectrum evaluation.
But that's a really good start. You know? So you can always ask for an earlier one. You can always ask for an earlier status hearing. So you get someone, and you supply as much documentation as you can to that evaluator. And you talk to that evaluator, and you say, these are the concerns we have. You know, if you think they need more evaluations, please clarify that in your written report. You know, and urge them, we need this, you know, this needs to be urgent. This is something, this needs to be top of your list. Believe me, the squeaky wheel does get the grease in these things. So get that report back, and then ask for a review hearing with the court. You know, make sure that report is filed. Ask for a review hearing. Say, look, based on this, now we need these other evaluations done. We need these things finished. It really is, I mean, that's what I found in mental health, and that was why the public defender's office here has a dedicated mental health attorney. You need that person. You need to make that case your top priority and push, 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 push. It's how you've got to do it. I'll start repeating them too. There's a question over here.
You can also file a motion to show cause. I adjusted that on suitability. The department agreed a suitability needed to be done, and we had waited 2.5 months for the CLS attorney to submit the order to have the judge sign it. And she wouldn't do it. Oh, I'm getting to it. So I filed a motion to show cause and started asking for hearing dates, and lo and behold, the order came the next day. And suddenly we have our suitability. So obviously, if you can't even get it in front of the judge, file a motion to show cause, and lay out the grounds as to why you are not getting the response and the order that you need to get this child the services you need.
And that is a good point. It is amazing when you get, especially if you can get that hearing and you've now forced some higher up attorney with CLS to have to come to court. Yeah, it is sometimes amazing how quickly things can get done so that they don't have to come to court.
One of the things, and I know there may be a lot of disagreement about it, but I know that the kids are allowed to be part of the process and to come in. You say that you do their best interest and their expressed interest. I've got kids that go to the suitability, they get to make a recommendation, and the kids don't want to go because they can't take their cell phones. And when I'm speaking in front of the judge and magistrate, I'm saying, you know, we're allowing children not to get the services and the help that they need based on, I don't want this. But in other medical decisions, you would not allow them to walk around on a broken leg because they say that the cast doesn't match the shoes.
So the discussion is that if you have the children who come and express they don't want to go, so essentially you're saying in your situations you found the judge is agreeing a lot of the time.
The judge is doing suitability, and and I know kids have to have a buy-in because it doesn't make sense
Right.
to go to a program, get involved in it, or not get involved in it, and just kind of be an observer. And I understand that. But at some point there has to be adults in the room that do what's best for a minor, for a child, as I would do with my own child. I wouldn't go with my own child, sit in, have everyone telling me, this is what your child needs to be better, and then turning to a 10-year-old and saying, well, would you like to go? Would you like to take the medication? Oh, you don't want to? Okay.
I'm surprised. Almost every MDT and suitability, both delinquency, dependency I've ever gone to, 99% of the time the child says, I don't want to go to residential treatment. I don't think I need it, you know. And it could be some silly reason like they won't let me take my cell phone, or, you know, a very good reason.
No, they've heard
But-
how it is. That's the other thing.
Right.
They've heard and you know exactly how it is because
But-
someone told you.
Vast majority of the time, the recommendation is for residential. How many of you have sat through MDTs or suitability assessments? How many of you would say that the majority of the time it comes out not recommending residential? About half. So yeah, that's surprising. Because I guess here in Central Florida, every kid goes into residential treatment.
And see where we are, there aren't the services to
And,
out.
and what does that come down to?
No,
money.
They're
Money. There's not the
money
services.
to transport them to other places. You have caregivers that may not want to drive 80 miles
Yep.
to take them twice a week.
Right, so if you have limited, here in Central Florida, we have hundreds of beds for kids to have residential treatment. So yeah, in certain parts of the state, if you only have 50 beds covering, 5, 6 counties, it is only going to be the most needy cases that get there, and that clinical utilization manager is going to sit there in that suitability and MDT and sit there and go, okay, I got 50 beds and we already got 48 of them filled, and and this, if there's any wiggle room, that's probably why you're finding that they're not putting them there.
I do the out-of-county courtesies for SIP program. I do the out-of-county SIP for the GLs around the state. There's 24 beds at that SIP in Orlando, and I do 20 of them, which means there's only 4 kids that are at that, out of the 24 that are actually from Central Florida.
Well, where we are, we have the juvenile detention.
Yeah, right now I have a youth from Pensacola, Key West, Miami, a lot from 12, 13, and 20. So I don't know if they just don't have the beds there, but for some reason, 12, 13, and 20, those circuits send kids here a lot.
Yep. Yeah, and that's one thing I apologize for. I did not look up to see currently how many SIP beds are there in the state of Florida. I mean, do you have any idea? In total?
10 installations.
Right.
SIP program, most of them average 20 to 30 beds, so there's maybe 200.
Right, that's what I was thinking, maybe 200 across the state that are SIP. There's probably another 200, 300 more that are private, but the vast majority of our kids in dependency, delinquency are not going to have the health insurance to get private beds in mental health facilities. So let's look, yeah.
I just want to say something to this discussion. I know you've already said it. Having beds or not having beds should not be the decision that the qualified evaluator is making when he's making or she is making a decision as to that suitability assessment. And there's a lot of due process involved in this. If you feel like a suitability assessment has been denied improperly, the standard is emotional disturbance. And you can have a hearing on that and bring that qualified evaluator in to get an understanding of how he or she made that decision. We have done that in our area, and sometimes we have found they have not had all of the information or review all of the information. And we have been successful in getting that overturned. That's an unpopular position to take, an unpopular method to use, but it is available. So if you have the standard, which is emotional disturbance, and you can prove that by another evaluator or having the appropriate documentation, all comes down to proof, of course, you still can get the services your children need.
And what area are you in?
Fifth Circuit.
And have you found that when you do challenge if you can get your judge to give you the hearing time and you actually get those evaluators in and sit there on the witness stand and answer, how many times do you actually have to do that before you start getting really thorough assessments?
I can say our evaluator he's not rattled by having to come to court. If he has a decision he's going to make on it, he makes it. I can't really say that it's changed him, and I don't blame him for that. He's independent, and he just provides whether or not he had enough information or not.
Yeah, but it is one of those things, and that's from the legal side, that is the push that we have to make. I mean, people don't like to come to court and testify and things like that, but if the process isn't being followed, like what you were saying, not even really doing suitability assessments and that sort of thing, if the process isn't being followed, You push that and make them cover every detail just a couple times, a few times, believe me, it will get fixed.
No, one other comment. Guardian ad litem is technically a nuisance. You know, we came into this thing for compassion. We have no psychological training. The longer you're around, the more you learn. I learned that all SIPs aren't equal, okay?
Oh, no.
And the best
Or
thing you
private
can do
treatment's
is
not
go to
equal.
Sunshine Healthcare, has a skills-based chart for each SIP. So if your kid is ODD, PTSD, ADHD, you can look across. The psychiatrist that did the second evaluation after it's over with, I said, where are you going to recommend? And I'm not going to tell you the names of the places. He said, I'm going to recommend these two places. I said, well, they're thinking about putting her here. He said, under no conditions would I put her there. They don't have the skill sets to take care of her. And I said, well, we'll call you. He said, I will not answer that. I will not tell you that in front of a judge. Mm-hmm. Okay? So I got the thing from, and by the way, I contact them once a year, so I know I got the latest updated one, because I'm not convinced this child's not going to have to go back again because the services provided were no good.
But you can see the discrepancy between how these kids are getting treatment and coverage. You're down to the point of, you know, they're agreeing with the treatment plan and they're agreeing you're down to the point of arguing which is the best placement, and we've got people sitting 2 rows behind you going, I can't even get this kid evaluated. Right? I mean, and so that's what I'm saying, in a state like Florida, that we have this huge disparity.
We get a lot of the assessments done, and they don't recommend residential, but we can still set a hearing, and typically what we do to sort of undermine that recommendation is to have a hearing, because shortly after that recommendation, the child did 10 more things that were evidence that they really need this treatment, and then by the time you get to that hearing date, which isn't going to be automatic, it's going to be 30, 60 days, you may have enough evidence to move the case forward with the residential that the child may need.
Right, exactly. Just because you get the evaluation back and you get your hearing date, don't stop. Like, you've got to keep following up and keep checking. Okay, so we've talked a lot about DCF and SIP and their process. And I think we can all agree that it should be, pretty thorough. So now look at delinquency and DJJ. To have a child committed to a residential program, be it for mental health treatment or for anything else, they have to be adjudicated delinquent. This is the general standard is you have to be adjudicated delinquent of a felony offense. The rules have changed a little bit in the last couple years. They've been updated. You can have children who have had felonies in the past now be committed. You can have children who are habitual offenders be committed. 3 or more misdemeanors in 18 months can now be committed. So it has, and this is where you have to rely on the public defender, their attorney, to know the law and who can and cannot be committed to a program. But, you know, for most volunteers and everything, if you think of it from the point of view of the child needs to have a felony level offense and they have to have an adjudication, not a withhold, an adjudication of delinquency to get into a residential program. So essentially, they've gone through either a plea or a trial, and you have that adjudication. They then hold a staffing, and this is the child, the parents, the probation officer, the DJJ staffing manager, the attorneys, and you can bring in, particularly as the child's attorney, you can bring in anyone to that staffing that you think will help your argument with the staffing manager. The state attorney can bring in people that they think will help their argument with the staffing manager. It's kind of like the angriest mediation you've ever sat through. And it's very, you know, but there's no judge there, it's no evidence rules, it's not hearing rules, they can get a little crazy. That staffing produces a PDR, or a predisposition report, which goes back to the court, and that PDR recommends what they think the disposition or the sentence of the child should be. And they are the ones who also recommend, if it's residential program, what level of residential program that is. They should also be doing mental health evaluations of the child. They typically require an educational evaluation of the child, things like that. So all of that should come in. You should have that PDR at least 3 days before the disposition so that you have time to go over it, to, call your own witnesses to the disposition hearing, to dispute it or support it, whichever way you're going with it. So then a disposition hearing gets held. The judge can only determine what level, non-secure, maximum, they keep changing. It seems like every 2 years they rename the levels. They used to be, 2, 4, 6, 8, and then they went through all these other names, and then they cut them down to 3, and I think now they're back up to 4, 3 still. So the judge can only determine what level of commitment. The judge cannot determine what facility. Now, have I argued for the judge to put them in a certain facility? Oh, heck yeah. But I point out, you can't actually commit them to that facility, but you can commit them to that level of facility, and very often it's a lower level than what the PDR is recommending. You can't, here I'm giving you the reasons for the record. You're looking at, they need this sort of treatment. It's only available at this level of facility. That's why you're going, you're going off of the PDR and you're dropping them a level. So you need to know what those facilities, just like it's good to know what's going on in the SIP programs and the DCF programs. DJJ, it's hard to find those, I think. DJJ is very easy. It's on their public website. I shrunk it down to a spreadsheet for you all. It's on the documents. It tells you the name of the facility, what level it is, boys, girls, what the ages are, and exactly what treatment programs, educational programs, everything they offer there. So if you know that, you have a child who one of their diagnoses is anxiety, they don't do well in large groups, do you want them in the facility with 50 other girls? Probably not. Do you want them in the facility that is specific for mental health overlay services and that only has 14 girls at a time? Probably a better option. And what I found is if you work with the DJJ, you get, kind of buddy up with the DJJ staffing person. If you can get them during that staffing, because they will not do it in court. If you know these programs and you say, but, these and these and these, it sounds like this is really the best option for this child, so can we recommend that level of treatment? Getting it done in the staffing and having it come out in the PDR makes your job a lot easier at the disposition hearing in court. Now you're shaking your head going, never gonna happen. I mean, I've had some staffing managers, that's never gonna happen.
It is an anchor staffing, and this one child, when she's had 56 placements in a year and a half.
Did you hear that? 56 placements in a year and a half.
We went in October, and it was just a pile up of, violations of probation and, thank you, and not going to school and that kind of thing. And she didn't want to go into a SIP because she couldn't take her phone, and no one insisted that she get the mental health services. So we get to this point. When we walked in, guardian, CAM, the probation officers, the public defender, I knew in October there was nothing that we could say about this kid that was going to get her the services that she needed without her going to jail. I saw her last Friday. She's been there 2 months in this program. Okay,
And this is a DJJ or a DCF
in a DJJ program. They completely disregarded the fact that this kid needs trauma counseling. The case manager and I have been working, we've gone over and we've kind of schmoozed with the people at the facility. So yesterday I got an email that they're going to allow us to bring in a trauma counselor for her. This ticks them off because they want everybody to do the same thing. But that's what this kid needs. In 3 months, she's going to be 18 years old, and she's 17 going on 4, because all the time she's been in care, she has not gotten the services that she needs. She's not getting educational services now. That's what they're supposed to do. They're guilty in this facility of educational neglect.
Oh, the vast majority are.
But she's in jail.
And
That's
it's
the
and-
only thing they're doing well.
And it's-
They're punishing her.
And it's almost like a lot of these programs, and sure, I think a lot of the times, yes, you can blame it on the money, but sometimes not. I think a lot of it is, it's almost like they triage the services. Like, well, the kid needs some mental health help and they need to get stable before we can have them in a classroom setting. You know, in the meantime, you expect this mentally unstable child to do online school.
Well, they have 50 kids, because there are 58 programs in the state. There are only 8 that take girls, and they're scattered all over. And they're probably different levels, which, you know,
Yep.
we didn't know that. But they're saying they're testing. They have been testing for the 2 months that she's been there. And their explanation for her not getting educational or mental health services that she needs is that, well, we have a lot of different kids at different levels, and sometimes we can only test 1 a day.
The state law says, even in inpatient care, the school system is required to provide education.
Right, right.
March through the end of the school year, you know how much instruction my client got? Zero. Zero.
But the school systems will get around it by saying, well, we do have someone in place in that program. Now, whether they actually see every kid in the program, no. So yeah, they do, I mean, they find all the loopholes to get around that. So, I want to make sure that we get through some stuff. So let me move through the DJJ stuff. So I think we've got to the point, so everyone understands that with DCF, you're looking at more of a, you know, series of evaluations, the series of treatments, that's all in a case, it should be in the case plan for the child. And it's almost as if you can go through and you have that checklist. DJJ is so very different. You know, it essentially comes down to this child was found guilty of a delinquent offense, they're committed to this program, here DJJ, now you do everything. You know, and even the fact that you said that you've even been out to the facility, you know, you can't, hardly anyone ever does. If you have never been to a DJJ residential program, find the one closest to you and go tour it. They will give you the tour, might take a while to get set up, but go see it, and then go see your kids that are in the DCF programs. They're very different from each other. So, and that's one of my points, to think about what is, you know, so you've got to consider, is residential treatment the best thing for the child? If you've gotten to the point where even you can agree it is, this is the only way to keep this child safe and anyone around them safe, and it's gotten to that point, if you've got a kid who's in both court systems, who you have the option, you've really got to look at, are we going to try to push for treatment through one or the other? How many of you have a crossover court system? You've got delinquency and dependency being together. So very few, yeah. And that's what we found. We don't even have it in Seminole County. So if you've got that option, and you've got the one judge who knows both those cases, use it. You know, you can push for one over the other, whichever will give your kid the best treatment. But if you don't have that, you've essentially got 2 judges you've got to go argue in front of. You know, that's when you've really got to push getting hearings and things like that. So if you think about DCF versus DJJ, and DCF for a child, you've got a treatment plan for that child. It should be part of their case plan. It's an indeterminate time frame, but they will only keep children in a residential treatment until the child is stable or, you know, can be released based on that clinician. It's intended to be a temporary placement, and it's monitored by their case manager and the clinical utilization manager. The facilities are very different. They typically offer normal, you know, freedom of movement to a certain extent. The kids are typically wearing their own clothing, you know, that's where they're not in jumpsuits or uniforms. They can often bring some of their personal items with them, usually not cell phones, but, you know, they can usually have their own personal items in their possession. Whereas DJJ is very different. DJJ, the judge has to order that program until their 19th birthday. And if it's a maximum, they can put it until their 21st or 22nd birthday in some cases. No, what are they down to now? Capped at 21? Okay. They got rid of the 22? So you can tell how long it's been since I've worked in delinquency. So, but that's, you know, even when the mental health treatment, the child may be stable in that program, and the mental health treatment services might have ended, they're still in the program. You know, the program, we don't like to say delinquency is punitive, but it is to a certain extent, and that wording comes back and forth in the description of delinquency. But it's, you know, well, we have to keep the community safe. So chances are the kids are going to be in those programs a lot longer than in a DCF program. The mental health treatment part of that program could actually end up extending that program. If a, you know, non-residential program for that facility, they say, oh, you know, it might be, you know, 6 months, 9 months, that sort of thing. If they do mental health treatment first, I've had kids who, oh, well, we're in the, you know, mental health treatment part of it. Then they'll go into our behavior modification part of the program, and that's where the 6 to 9 months begins. You know, so you have a kid who maybe you've gotten them prepped for, you know, if you really work the program, you know, you might be back home, you know, on monitoring or something within a year, and now they're finding out it's not going to be that way. Yes. Yes.
They're not getting a lot of the services that they're ordered to get. In the Ninth Circuit, we've been able to get the judge to order that receive or DJ give services while they're in the JDC that they're able to.
Right. And that's, and the comment was for the recording, the comment is that the law, as of a couple of years ago, I think it changed, is that any child committed to any level of residential treatment program shall be detained in the local juvenile detention center. So, and like Ronnie said, they are not getting treatment services there. They're lucky if they're getting decent school there. So they can sit there easily 4, 5, 6 months before they're off to a bed in that program. So, you know, one of the things that I've argued even with DJJ is, can we get them, you know, maybe we were debating, you know, the staffing manager is debating between 2 placements for the child. You find out one of them has a bed, can you go ahead and get them in that program and then transfer them to the other one when the bed opens up? Can we at least get them somewhere where they're getting some treatment and appropriate services for them versus sitting in the JDC? So that's the other big difference. I mean, I think you're starting to realize from my perspective, if I had a kid who had an option, if I had a delinquency client who had an option to get treatment through a DCF program, I pushed for DCF over DJJs all the time. You know, and the kids in the DJJ programs, they're typically wearing some sort of uniform. There's usually no personal items in those programs. It's very restrictive, it's locked down. You know, the levels of security depend on the level of the program, but they're typically locked doors, you know, barbed wire fences, razor wire, you know. It's a very different feeling. It's the feeling of a jail or prison for children. It's not the feeling of a hospital treatment facility. So if you have not seen those, please go visit them and see the difference. So we've only got about 15 minutes left. I want to run through some of the research that I did when I was looking at this to see if I could find, I was really initially looking for studies specific to Florida about mental health treatment for children who are in the juvenile justice system. Didn't really find anything too on point, but I found 3 research articles that are within the last few years, because the laws do change so quickly here, that I think, you know, will help you either just gain insight or it might give you some points to argue. You can always provide these to your evaluators, provide them to your experts, put them in memorandas of law. You can do that to start to get this knowledge across. I mean, you know, the chances that you're going to get this researcher to come testify for you in court, not likely. But you can get this information out there. The first one is an article called Mental Illness in Juvenile Offenders. This is on the app. The program is in there. So the basic abstract of it is that they're looking at how delinquency and mental illness co-occur. They're looking at the treatment programs for those youth, and they're finding that the whole system of care is the most appropriate treatment. It gets into an excellent description of treatment models. They go over 8 specific intervention treatment models and how the juvenile justice system can use those services for delinquent children. And then they get into a quick discussion of advancements, implications, kind of things for practitioners. The key things that I took out of it is their research overwhelmingly showed that long-term confinement for children does far more harm than good. Typically, it actually increases recidivism and continued offending. They posit this theory that because public mental health services, essentially the funding for children, dropped so much in the 1990s, that the communities to fill that need, because we certainly didn't have less children who needed mental health services. What communities did is they started using the juvenile court system, which also began in the early 1990s. They started using that system to fulfill that need. That comorbidity, having more than one mental disorder, is very common among adolescents. Almost 2/3, they estimated nearly, over 60% of kids have at least 2 or more mental disorders. And that the different diagnoses, the different needs, that because of that you have to have so many varying levels of care. You cannot, in my opinion, as DJJ tries to do, slot kids into 3 levels of care for residential treatment. It doesn't work that way. An 8-year-old compared to a 16-year-old, you're talking huge differences there. What their delinquent acts are makes a huge difference. And then throw in all the stuff we know from dependency, past traumas, family history, educational background. You can't slot kids into a few systems and expect it to work. That to determine that proper treatment, you've got to have effective screening and assessment processes. I teach this when I help train our volunteers for Guardian Ad Litem. The look on their face when I tell them, question that doctor's report. If you read that report and something in your gut goes, it doesn't seem to match the kid that I met. Question it. I don't care how many degrees they have. You can question them. Maybe they've gotten lazy. Believe me, I've met plenty of psychiatrists and psychologists who they do a 45-minute evaluation and check off a bunch of boxes, and they literally use a template. I've gotten reports back with the wrong kid's name because they were literally using a template. Question them. Don't be afraid of them because they got a bunch of college degrees. You've got to have that appropriate assessment and evaluation. And as they point out, they describe it as a weighty task to put on one system of care. In this case, they're referring to the delinquency system. So the 8 treatment models that they look at are here. I'm just going to you guys can read this, it's in the handouts, quickly go through them. Cognitive behavioral treatment model focuses more on social cues. A lot of you have heard, DJJ used it for a while, a program called Thinking for a Change is one of the strategies under CBT. Integrated co-occurring, it's used in a lot of stuff. This is probably one of the more common one that's used. They do a lot of what they call motivational interviewing to facilitate the child to be ready to change. So when you talk to the kids when they first get into these programs and you say, well, did you and your therapist talk? Are they talking to you? Well, we just kind of chit chat about the day. That's part of this whole thing, is building the rapport and trying to get them motivated and that sort of thing. Functional family therapy, difficult to do when we have a shortage of foster homes in general, much less foster homes who are willing to participate in treatment with a child. because that's what you need for the kids in these programs. Family integrative transition is also used, but it's a pretty intensive, rigorous program. If you think about the fact that a lot of our delinquent kids are coming from homes which, but for the grace of God, are not in the dependency system, to get those families to participate. I mean, these are things where it's like you have someone coming to the house every day for a week and doing 2-3 hour sessions with the whole family, and this one is, it works really well. It's got a low recidivism rate, but it's probably not likely to be fully complied with by the family. Multi-systemic therapy is also pretty common, considered to be one of the most effective treatment models for delinquent youth. Pretty low recidivism rate, so this one is also often used. And personally, I think a lot of the things fall under multi-systemic therapies simply because the therapy providers change so often. So kind of without actually meaning to, the families and the kids are going through different therapy options. How many of you have a wraparound program in your county? Seminole has it, Orange has it. Just a couple. What county are you in, sir? Osceola? Yeah, right. Osceola, Orange, Seminole has it. But most of you don't have it. It's been great for us. It's a great program. But it essentially uses every system that the kid's life might touch, gets involved in that wraparound treatment model. Like, one of the best things that's come out of wraparound for us, at least I know Seminole and Orange have, I'm not sure if Osceola can say this yet, but we have a system where essentially the parents can call, like usually here they call 211, which kicks them to a United Way operator. That kicks them over into wraparound. They can essentially explain that, I have a child who, has a diagnosed mental health issue. I'm having trouble controlling them right now. I don't want to Baker Act them. I don't want the police out here. I need help. I need help with this child. They will have a licensed clinical social worker out to that home within an hour who is trained in tactics and talking a child down and things like that to try to avoid the police coming out. The police, at least in Orange County, and I believe now the Sheriff's Office in Seminole County is starting to utilize it too. If they get on scene and realize that's really the issue, this is not a situation where you actually want to arrest a child, there hasn't really been a crime or a delinquent act or something like that, they will even call and can get people out there. So if you don't have wraparound, try to find out who can. The United Way is usually kind of who kickstarts it. See if you can get that in your community. But it also has a very high success rate.
The presentation by Sunshine Healthcare, they now cover that.
Yes. So that's why I think it is going to expand in Florida. Because it did expand. I saw it first start in Orange County, and then when I heard it had expanded to the Tri-County, I was really happy to hear that.
Grant, and it has to be run under a government program. It has to be the money person. Seminole County Sheriff's Department has it. The Orange County government has it. And Osceola, the school district has it. But we all use the same therapist and kind of coordinate all three of them together.
Yep. And multidimensional treatment, foster care, these are alternatives to group, residential, secure care sort of thing. They're placed, as I'd mentioned this before, you have highly trained, very specifically trained local families who expect to only have the child on a fairly short-term, maybe 6 to 9 month basis. They do a lot of family therapy as part of that time with the children. And they found that these children typically have far less detention time, and it's another very effective model. But like I said, in areas where you already have a shortage of any kind of foster family, to get the right people, to get a foster family who could do this is extremely difficult to find. How many of you know that your local law enforcement has CIT officers? should be most places around the state. But it's usually pretty low. But crisis intervention teams is specialized law enforcement programs. Most of them try to have at least a few officers who they call JSITs, who are juvenile trained specifically. And it was specifically developed, I don't know, maybe 10, 15 years ago to address that school to prison pipeline issue. But they're very highly, the officers who are CIT go to the same 2-day training that all the juvenile competency evaluators go to, because I've been to that and spoken at that as well, and it's, the CITs go there too. Yep.
I relocated from the Northeast 2 years ago, and the victim specialist I relocated from the Northeast about 2 years ago. I was with law enforcement there. A lot of the victim specialists that are attached with law enforcement, and so there's victim specialists or law enforcement victim advocates. You can reach out to them,
Yes.
connect with them, and they do a lot of the crisis response. They'll work with the mobile crises. For the most part, law enforcement is mental health and juvenile justice trained.
And thanks for reminding me of that, because along with I would try to remind both the parents of my delinquent kids as well as even families that we work with now in dependency. If you're calling the police to Baker Act a child, when they make that call, ask them, get in the habit of asking for a CIT officer to come out. Because the CIT officer may be able to talk the child down and not have to do a Baker Act. But that's a good point, is if they say, well, we don't have CIT officers available right now, say, okay, do you have a victim advocate who could potentially come out? So, I would always tell people, if you've gotten to the point you have to make that call, it doesn't hurt to ask. Do something to see if you can avoid that situation.
Since we have 100% coverage of school resource officers, why aren't our resource officers trained in CIT so that
some
they're
are and
not
some aren't.
arresting the kids? Because
Yep.
this is the option.
Well, on the one hand, we don't want that highly trained, a CIT officer, stuck at a school for the whole school day. But I do agree with you. School resource officers should also be trained in CIT. I completely agree with that. So maybe there's a new legislative push for Alan. But yes, I agree with that. That would be, when you're at the school, that'd be a great thing to ask. Find out who the SROs are at the school and find out who, if any of them, are CIT trained. So that would be a great question. Quickly.
Question really quick?
Yep.
You're talking very much about like the high end of the breakdowns, when we're Baking Act, SIP, anything like that. These call-outs, a lot of times, don't you find, also are for the lower end? And if you're asking for these professionals to come out and say, oh, does he need to be Baker Acted? You're kind of going to the extreme, because some of these kids are just having a tantrum or an outburst that we don't necessarily need to get to that level. So do you find, what would be someone reaching out for help but wants a lower level of services? They don't want to call the police. They don't want to ask for who should they be calling?
To me, they need to be, if they have 211 in their county, use 211. That's the United Way feature on the phone that disperses to various social service agencies. Make sure they have the number for the local mental health care, like here locally, it's Aspire that does it. Make sure they have the number for those facilities so that they could see if do they have any mobile units and things like that. But yeah, I'm kind of focusing on when you've gotten to the high end of mental health issues. So quickly, the last two articles that I would suggest you look at is Ms. Cannon's article. It's a law review article from DePaul Law Review on community-based mental health treatment for children. It is lengthy. It's 80 pages long. It's got really great footnotes, though. I'll give her that. I'm not sure, does anyone here know this woman? Anyone no? Just because I would say, my opinion from reading this is that it comes across as a little naive. I read it as, a person working in court, I read it as I don't think you work in court a lot. It was like, yeah, sure, we'd all love to ask for those things. Good luck. But I did, when I looked at her bio, she's an assistant professor at the University of New Mexico School of Law, and she runs their disability rights clinic. So I don't know how much actual real life court, she's more of the academic than the litigator, but it does have really good points about using the different systems. She calls them legal regimes related to child welfare, juvenile justice, different things, and it's interesting the way that she breaks down each of these, what she calls regimes, and shows how you can apply them to mental health treatment for the children. So it's just, to me, it's a good way to kind of frame an argument from a really holistic approach. She gives a lot of good ideas for that. And like I said, she goes through like these 5 regimes, and she also found community-based mental health treatment far more effective than residential, than locking kids away somewhere, taking them out of their community. So again, it just kind of goes to and that's my point, is everything I found says you've got to push that every community-based treatment option has been covered before you look at residential treatment for these kids. The last one I would suggest, I did not provide on the documents because it's proprietary to this science and business media company, but Samantha Kemker, the primary author of it, is very fast to respond. You can email her at her Gmail account and say, hey, Ms. Kemker, I'm really interested in your article, but I can't, I just don't have the means to buy it online through this company, because it's like $30, $40 some to get this, like maybe 20, 30 some page article. If you just email her, she has the right to distribute it for personal use. So if you just email her, she sent it to me within an hour. She was very quick to respond. So was also a really good one. So they're looking at specifically, they did a lot of research based on a lot of data from 3 counties in Texas over a 2-year time period. And they were looking at 3 specific hypotheses. I'm going to jump because we're out of time here. But they looked at, they talk about externalizing and internalizing psychopathology, and they do explain what that is. And they looked at, essentially, if you look at just the diagnosis and just the gender, can you predict where a kid is going to go for treatment? And of their 3 hypotheses, they were fully supported or partly supported. So they did essentially find if you have, violent offense, what they call externalizing psychopathology, a mental disorder that results in an external, like a projected issue, especially if it's violent, you combine it with substance abuse and they're male, they're going to go into residential treatment. If you have a female who has an internalizing psychopathology, like a mood disorder, like a depression, and there is no violent delinquent act, something to that effect, she's much more likely to get community-based treatment care. So it's just an interesting look at, based on, you take these just, black and white factors of a child, can you predict where the courts are going to send them? And for the most part, they said, yeah, you kind of can, unfortunately. So has any of this changed your perception of how you would argue for treatment for a child and maybe using one system over another?
I have a question in reference to, yesterday I heard that, and I did not know this, that certain things can cause a child to get a felony against them. Mm-hmm. And they said that a felony is for a lifetime. Now, if a child got a felony, but found that he needed to be in a support system or facility or whatever, can they remove that felony from his record so it isn't there anymore?
Well, in Florida, you can only essentially remove one charge in a lifetime. One. I mean, how many of your delinquent kids only have one? And I don't believe, we argue this all the time as delinquency people, there's the argument that, oh, your records are sealed at 26. That's a certain time frame after you turn 18, all this stuff. I don't believe that. In this day and age with computers and technology and this, just because the clerks allegedly, delete them from the system and shred the files and all that stuff, it's still sitting out there on a server somewhere. And it's also very clear in the law that certain background checks, like the military, they get everything. Delinquency records are not sealed to the military. So knowing that you can only lay term get rid of, legal term seal and expunge, one record at one time in your life in the state of Florida, I wouldn't waste it on a juvenile offense. I'd say, what if you're that guy, you have these, not too bad juvenile history, suddenly at 38 years old, your stepdaughter accuses you of a lewd and lascivious act. That might be something, you get that pled down correctly, even that can get sealed and expunged. Sex offenses in general, no, but you get it down to the right ones, you can sometimes get those sealed and expunged. I always advise my juvenile delinquency parents, don't blow it on this juvenile stuff. The vast majority of employers' background checks things, it's not going to come up. It's going to remain a confidential file. So.
I think the court recently ruled that while you can do that with the judicial record, you may not do that with the press.
Right, you can't do it with the press.
So
you can't do it with medical records.
Every day in Pensacola, they have a list of all the arrests that were made the day before. Not convictions, just arrests.
Right.
So if you go search on that, you find this poor kid there 3 or 4 times.
Right.
Doesn't matter what's in the court record.
And good luck convincing the general public that we're innocent until proven guilty, so an arrest really doesn't mean anything. That's the public defender in me talking. There were a few other articles. I put them in the bibliography if you want to reference these that they get a little bit more off topic. They get into specifically psychotropic meds. They get in specifically about educational needs, but it was very related to kind of cross occurrence with children with mental health issues. And they get into the crossover court practice model and issues with that. They call it service integration, but it did focus a lot on mental health services. So those are some other articles if you kind of got a more specific issue you're looking at that can help. And that should do it. Feel free, if you think of anything, follow-up questions, or hey, I have this scenario, please feel free to email me or call me. I'm happy to help out and answer questions, and thank you all for being here.